Welcome to the very best part of my broadcast week at Takeout First. Associate Supreme Court Justice Neil Gorsuch. The main topic, his book, Overruled. Justice Gorsuch, great to see you. Thanks for the time.
Nice to see you.
Who's this book for?
This book is for all of us, we the people. It's a book about whether we maybe have too much law in our lives right now. James Madison obviously thought it was very important for us to have law in order to be free and to be equal under law, but he also saw the dangers of too much law in our lives. And I think it's worth asking where we stand today on that metric. Like everything else in life, there's a golden mean. Too much, too little. And all American people have an interest in their government, making sure it works and works well. So it's really a book of stories about the American people and their experiences in a world with a lot of law these days, and how much of it has changed just in our lifetimes.
Most books are written to fill a void. The author says, something hasn't been said, and I need to say it. What void is this book trying to fill?
Well, I've been a judge now for about 18 years, and I just saw so many cases where ordinary Americans, decent, hardworking Americans, were just trying to make their way in life. They weren't trying to hurt anybody, and yet they were caught up in the legal system in ways they couldn't hardly expect. And so it really is, it's a book of stories about the cases I've seen, that other judges like me have seen, cases about fishermen in Florida, monks in Louisiana, a magician in Missouri, and their experiences in a world where law has really exploded just in our lifetimes.
Are they victims?
Well, I think their stories are tales that all of us should consider. I don't know whether you consider them victims or whether you consider them emblematic of a world in which we just have so much law. I mean, today we have 5,000 maybe criminal statutes on the books. And what happens when a fisherman like John Yates gets caught up in that? May I tell his story?
Sure.
So John Yates is out on his fishing boat, and somebody comes up to him with a badge and says, I'd like to look at your fish and make sure they're the right size. He spends all day going through thousands of pounds of fish and finds 72 he thinks are undersized. He says, put them in a crate, and I'll deal with you when you come back to dock in a few days. A few days he comes back to dock. He measures them again. This time he finds 69 that he thinks are undersized. The limit at that time is 20 inches, mind you. All of them are above 18 inches. And nothing happens. He doesn't get a citation, nothing. 3 years pass, and then several agents show up at his home looking for him. He doesn't know why. He's eventually taken 2 hours away and booked and charged with violation of the Sarbanes-Oxley Act. That's an act that was adopted after Enron to deal with financial accounting problems. And the theory is that he had thrown 72 fish overboard because they were undersized and replaced them with 69 new undersized fish. Now, John thought that was a pretty far-fetched theory, but that was the government's theory, and they charged him with a provision of the Sarbanes-Oxley Act that exposed him to 20 years in federal prison. Well, by the time he went to trial, can you guess what the size limit for red grouper was at that time? It was 18 inches, yet they still pursued him. And they pursued him all the way to the United States Supreme Court, where he won in the end by a vote of 5-4. Now, he was ready to stop after his trial and after he'd served his time. He didn't get 20 years happily, but he did spend Christmas in jail when he was busy trying to raise 2 young kids, his grandchildren. But his wife, Sandra, insisted that they take it all the way to the Supreme Court because she didn't want to see happen to others what had happened to him. He won, but what did that win look like? By that point, he had lost his job, his fishing license. Well, I don't know if he lost his license, but he lost his boat. And she became the sole breadwinner for the family, living in a triple-wide trailer. Now, I think it's worth asking, do we have a problem here? And that's what the book's about, stories like that.
Having read the book, would I be wrong to wonder if your observations about COVID influenced the arc of the book or reinforced some of the concerns you're raising.
Yeah. Well, I think COVID is an interesting case study of what happens when lawmaking moves from the legislature, right? During that period of time, legislatures largely fell silent, so did courts. And we lived in a period with intense regulation from executive sources, edicts, decrees.
Governors, mayors, county commissions, et cetera.
Change week by week, jurisdiction by jurisdiction. Now, that was very important, obviously. I mean, it was a very dangerous time in this country, and we needed some emergency rulemaking, obviously. Everybody knows that, and there's nothing new. James Madison would have said the same thing, that in times of emergency, the executive has to act strongly. John Locke would have said the same thing. But it is worth asking what happens when rulemaking goes out of the legislative branch and into the executive branch. And in that, COVID had some instructive things in it, I think. First of all, what happens to equality? Who's best able to deal with shifting regulations that change from week to week, from place to place? Maybe the bigger companies? Maybe the small mom and pops have a harder time with it? Well, you saw during COVID that billionaires saw their net worths increase by 70%, while mom and pop businesses lost out. We saw regulations, it was unlawful to congregate on street corners, but who were those rules enforced against? There's a fair amount of evidence that suggests they were disproportionately enforced against African American citizens. So I think there are some questions that are worth asking.
Were religious liberties infringed upon at that time?
Well, those cases obviously came to the court, and a classic example out of Nevada. Who do you think benefits when decrees are made without the involvement of the legislative branch? Maybe favored industries. Casinos were allowed to remain open. Churches were closed. So I think that's the answer to your question.
On page 3, you write that law in America has swallowed up ordinary people, intentionally or unintentionally.
Well, I think all with the best of intentions. I don't doubt, for example, that the fellow who was coming on board John Yates's boat had the best of intentions. Let me give you another example, if I might. Is that all right?
Sure.
Marty Hain from Missouri. He's a backyard magician.
Mm-hmm.
He does children's shows. One day, he's doing his show, and he pulls a rabbit out of the hat. Got to do that, right? And somebody comes up to him and says, "Do you have a license for your rabbit?" And it shows a badge, U.S. Department of Agriculture. And he says, "Why, no, I don't have a license for my rabbit. Do I need one?" And they engaged in a conversation. It turns out if it had been an iguana, no license required. If he had intended to use his rabbit for stew that evening, no license required. But because he pulled it out of a hat at a children's show, he needed to have a federal license for his rabbit. Well, Marty, I don't doubt the agent had every good intention in the world. But I also don't doubt that Marty had every good intention in the world. And of course, he dutifully applied for his license, and he got his license. Sometime later, he got a notice, though, that after Hurricane Katrina, he had to have an emergency preparedness plan for his rabbit. And it had to cover everything from hurricanes to chemical spills. Well, Marty explained to an agent that he lives in Missouri, and there are no hurricanes, and he keeps the rabbit in his house. But he does have some worry about tornadoes, and his emergency preparedness plan is to make sure the family's in the basement, then the family dog and the cat, and then, if there's time, the rabbit. Well, that didn't go over well either, as you can imagine. The agent said, "Well, I only care about the rabbit, the cat and the dog, I don't care about this. So the rabbit has to come first." Fine. He wrote a 28-page emergency preparedness plan, had to hire a lawyer to do it.
More of our conversation with Supreme Court Associate Justice Neil Gorsuch when we come back.
We have more people serving life sentences today than we had serving any sentence in 1970.
Welcome back to the Takeout. Let me just set the scene a little bit for this interview. It was based on a book pitch that came from the Supreme Court on behalf of Supreme Court Justice Neil Gorsuch. And the pitch was, he's got this new book. We'd like to talk mostly about that book, but you can weave in other questions. So a fair amount of this interview is about the book, and its premise is there are just too many laws in this country. Too many laws passed by Congress, and too many executive actions taken by governors, mayors, county commissions, especially during COVID, and that comes up in this conversation as well. So, more with Associate Supreme Court Justice Neil Gorsuch.
We've gone from a world in which all federal law, codified law, could fit in a single volume to now where it occupies a whole wall in my office, where federal crimes have maybe doubled in our lifetime, those that are just in the code. And then if you go try and find all those that are in federal regulations, there may be over 300,000 of them. Nobody knows how many federal crimes there are because it would take years just to read them.
Is that supply meeting demand, meaning that there's a political demand for these laws and regulations, or is some insidious force inventing the demand and creating the supply?
I don't think there's any insidious force, but I do think the question you're asking is, why do we have so much law? I think a couple of things. First, again, just to set the table, right now we have 1 out of 47 Americans is subject to some form of correctional supervision. We have more people serving life sentences today than we had serving any sentence in 1970 or thereabouts. So that's the world we live in, Major. Why? You know, I'm not a psychologist or a social scientist, but I think some of it has to do with trust. We used to resolve a lot of things in our families or among ourselves or at our local level, as we've talked about. Mm-hmm. Now, I worry when more and more Americans think that people in the other political party are not just wrong, fine, but are evil. I worry when we are unable to speak to one another and listen to one another. When a third of young Americans report that they don't think it's important to live in a democracy. So I think a lot of it has to do with trust. When we don't trust one another, when we don't engage with one another, Tocqueville, when he visited this country in 1830, marveled that what might be done by a British lord or a French government was being done by the American people. They were solving their problems together in their own communities and coming together and interacting with one another. And we're losing a little bit of that, right? Where there used to be poker night, we have online gambling. Where there used to be bridge night, we have Wordle. We're interacting with one another less. We trust one another less. And I think when that happens, maybe there's no place left to turn but law.
You write somewhat fondly, and justifiably so, about Daniel Webster's quote that miracles do not cluster.
Yeah.
Do malignancies?
I don't know about that. But Daniel Webster said that what happened here in this country in 1776 and in 1789, when we wrote our Constitution, was a miracle that took 6,000 years of human history to achieve. And he said miracles don't cluster, and don't expect what happened here to happen easily or again. And I do think that maybe sometimes we don't appreciate how much of a gift we've been given in our Constitution and our Bill of Rights. We don't even understand it anymore. A third of Americans can't even name the 3 branches of government, let alone know why we have them. That worries me, yes. If you look around the world, I just don't know where else you'd rather be, where your rights are more secure, where your freedoms are more realized, in anywhere in human history, in any place on the planet. I'm not saying we don't have our problems. Of course we do. Of course we do. But we've been given a great gift to govern ourselves. And I think Daniel Webster had it just right.
There's a conversation in our country right now that is more lively than I can ever remember it being, about what role this institution plays in the very things you're talking about. And a not inconsequential percentage of our country believes this court, as it's currently composed, is undermining things that they value and creating either reversals of precedent or pronouncements they are deeply uncomfortable with, and have caused them to question this court's role as a productive part of our institutional framework. How would you respond to that?
Well, I'll give you a couple of facts and figures to munch on. First, this court, you mentioned reversals of precedent, reverses precedent at a much slower rate than the Burger Court or the Warren Court that preceded it. Much slower rate. So that's kind of an interesting fact that I don't think many people know. And then I'd like to just back up for a minute and talk about the forest before we get to the trees in your question. The American people file about 50 million lawsuits every year, out of 340 million. That's a lot of lawsuits. I'm not counting your parking tickets or your speeding tickets either, okay? That's another 50 million. Put those aside, all right? But I just want to talk about the gift of the rule of law that we have in this country before getting to, and I promise I will get to your question. Out of those 50 million lawsuits, almost all of them are resolved at the trial court level. Somebody wins, somebody loses, but it's accepted by both sides as reasonable and fair. I represented a lot of people who lost in a trial court, but accepted it. They at least had the chance to be heard. A tiny fraction wind up in a court of appeals, like my old court of the 10th Circuit. I sat with judges appointed by President Obama all the way back to President Lyndon Baines Johnson. We covered 6 states, 20% of the land mass of the United States continent, 2 time zones, diverse court. We managed to agree on outcomes unanimously about 95% of the time. That's how determinate our law is, how clear our law is. What a great gift to live in a country where you know basically what your rights are, what the law demands of you and what it permits of you. That's without respect to party, right? Okay, well, what about our court, which is where you're getting at? We decide 60 to 70 cases a year. Those are chosen because that's where the lower courts have disagreed.
Agreed, of course.
That's predominantly why we take a case, is because the lower courts have disagreed. Strong opinions on both sides, good arguments on both sides. That's why they come here. There are 9 of us, not 3 anymore, like on the Court of Appeals. Can you get 9 of your colleagues to agree to where to go to lunch? We've been appointed by 5 different presidents over 30 years, from all across the country now. Do you know how often we manage to reach a unanimous judgment in those cases where the lower courts have disagreed? It's about 40% of the time. Mm-hmm. I think this term it might have been closer to 50. I think that's a miracle too, right? Daniel Webster. That's how determined our law is. And if you think that 40 or 50%, whatever comes easy, of course not. That requires friendships, collegiality, hard work, right? Finding common ground. My old friend Steve Breyer used to say, if somebody talks long enough, I'll find something I agree with. And maybe we should start there. Mm-hmm. And that's what we do. Now you're talking perhaps about the 6-3s or the 5-4 decisions. That makes up about a third of our docket every year. Now, I'm almost done, I promise. 6-3, about a third of our docket. Now those 6-3s though are not all the ones you're thinking about. About half of them don't contain the mixture of justices you might imagine.
Right, understood.
I read the other day that in ideologically divided cases, now I don't know what that means, this last term, that I agreed with Justice Sotomayor, Justice Kagan, and Justice Jackson something like 45% of the time. That's the court I know. Last. That 40% figure, unanimous cases, third, divided cases, that's the same today as it was in 1945, when Franklin Roosevelt had appointed 8 of the 9 justices on the Supreme Court. So I actually think when you look at the forest, you see nothing's changed since about 1945. I think we're doing all right.
We recorded this interview in the large conference room inside the Supreme Court, just off of the Supreme Court chambers, which is a kind of a cool place to be. I'd never done an interview there. And if you're curious, yes, lots of Supreme Court communications experts were hovering around this interview. When we come back for segment 3, we're going to dive deep into reversing precedent. We're going to talk about affirmative action and abortion. That's next here on The Takeout.
When it comes to Roe versus Wade, for example, what did the court decide? Decided that we, the people, should answer that question, not 9 people sitting in Washington, D.C.
Welcome back to The Takeout. Our conversation with Associate Supreme Court Justice Neil Gorsuch continues, where I press him on recent decisions from the High Court overturning what many Americans thought were settled precedents. There are people who will watch this right now and say, Major, you have to ask. I thought I understood what Roe versus Wade meant in our country. I thought I understood what affirmative action in college admissions meant. And this court has told me I didn't understand what those things meant, and I wrongly relied on things that I thought were settled. What would you say to those?
I'd say those are deeply complex legal questions on which reasonable minds can, of course, and do disagree. I'd also say to you that shouldn't we start from a presumption that those with whom we disagree love this country as much as we do? And that there may be good faith legal disputes on these questions? And then when it comes to Roe versus Wade, for example, what did the court decide? Decided that we, the people, should answer that question, not 9 people sitting in Washington, D.C.
How about affirmative action?
Affirmative action, much the same thing. What did we decide? We decided that all people are created equal, that it's not acceptable in this country to discriminate on the basis of race, echoing John Marshall Harlan's words in Plessy versus Ferguson in his famous dissent.
And for those who would say, but I feel something's been ripped away from me, you would say?
I would say that, in fact, on your first example, we're taking it back to you. We're recognizing that it doesn't belong to 9 people in Washington to decide, that we, the people, can decide these kinds of questions. That in a democracy, you're in the driver's seat, you're the sovereign. Those famous 3 first words of the Constitution empower you. Do you really want me deciding everything for you?
And for a woman in a state where she no longer has the rights she once relied on, is that cold comfort?
Major, all I can say is I don't know better than you do on these questions. There's no legal training or expertise that gives me any special insight into these questions, and that most major Western democracies have decided these questions through the ballot box. And they've managed to reach consensus on these questions, and I have great faith in the American people to do the same.
For those who watch this court and say there has been an accelerated and enlarged use of the emergency or shadow docket, and they are concerned about that process, bringing cases more rapidly and without briefs and oral arguments, short-circuiting the traditional process, what would you say?
I would say that we've always had an emergency docket. Every court in this country has what you might call an emergency docket. And it's an important docket for every court to have. If you are irreparably injured currently, shouldn't you be able to go to court and seek an injunction? That's what some people call an emergency docket. It's an injunction based on an irreparable injury that you're currently suffering. So it's something that every court has had since the common law. Every court in this country has, and this court's always had too.
You would disagree that it's been used in larger, more visible numbers? Because the statistics certainly indicate that.
I think certainly during COVID, we found that we were being asked to decide more things. Whether that will continue in the future, I don't know. But is it any surprise that in an era when you have, as we talked about earlier, rapid changing executive orders that treat people differently, the religiously faithful versus those going to casinos, is it any surprise that you have some emergency requests?
And you would argue against the accusation that interests viewed more sympathetically by the conservative majority of this court get their way more commonly through the shadow or emergency docket?
Well, as I indicated, I think in just this last term, the statistics that I've been shown suggest that I sided with Justice Sotomayor, Justice Kagan, and Justice Jackson 45% of the time. So in ideologically divided cases. Forget about those that we were all unanimous in. So I think the story of our court is 9 people, independently minded, hardworking, trying very hard to do their job and do it well and do it collegially. That's the place I come to work to every day.
Enjoyed the anecdote on page 50 about Sam Rayburn admiring the best and the brightest working for John F. Kennedy, but remarking that he'd feel more comfortable if any one of them had ever once run for sheriff.
Yeah.
Using that anecdote in our contemporary time, I wonder if you have any thoughts on the sovereign sheriff movement in our country, or the idea that counties have supremacy and counties have more effective law control and can defy either state or federal laws. It's a conversation in this country.
I confess, Major, I'm not familiar with that conversation. I am familiar with the federal structure and the supremacy clause and the authority of state governments.
And therefore supportive of those.
I take an oath to protect and defend the Constitution of the United States, and I take it pretty darn seriously, as do all my colleagues.
Is ignorance of the law an excuse?
Well, that's an interesting question, right? Traditionally, the answer's been no.
That's what I was taught.
Right? Absolutely. But what happens in a world where you don't know the obvious answers, right? That was always true when murder, theft, harming another person.
Mayhem of some kind.
Mayhem of some kind, okay. When those are the laws, it's easy to say ignorance is no excuse because you shouldn't be ignorant of those things, right? But what about Marty Hayne?
And the rabbit.
And the rabbit. Is ignorance of the law understandable there?
That's the question you want to raise.
That's one of the questions in the book.
What would James Madison, since you've referenced him many times, say if he were alive today to look at the legal landscape of our country?
Well, the first thing I think he'd say is he got pretty short shrift in Hamilton. Now, I love Hamilton, okay? It is a wonderful way to teach and learn about our Constitution and its history. But poor James Madison, I mean, it grieves me, all right? He was an incredible founding father.
What we know about the Constitutional Convention, we know because of him.
Only because of him and his notes. More than that, when I ask young people who wrote the Constitution, I can't tell you how often I get Thomas Jefferson as the answer. All right, now Thomas Jefferson was great. He wrote the Declaration, those important resounding words that we're going to celebrate the 250th anniversary of in 2 years, right? Those 3 great things that he said. We all have inalienable rights. We are all equal. And that the powers of government derive their just authority from the people themselves, that we are sovereign. Okay. I'm a huge Jefferson fan too. Mm-hmm. But Madison wrote the Constitution, the foundation of it, the Virginia Plan, the backbone of what became our Constitution. Jefferson was in France at the time.
So what would Madison tell us about our days?
I want to finish with this, because this is poor Madison. You know, and then he wrote our Bill of Rights too, Major, mm-hmm. right? And you know, many people don't know this, but he was so important. When important writing had to be done, the founders always turned to him. First time that Congress asked the president to offer a State of the Union equivalent in writing, Congress asked Madison to write the invitation to the president. He was then in Congress. When Washington received it, he called up Madison and said, would you write my State of the Union? Which he did. Mm-hmm. Went back to Congress, and Congress wanted to say basically thank you and add a few thoughts, and Madison wrote that too. So he invited, he responded, and he replied. He was also the last president of the United States to lead troops into battle, all right? So yes, but your question had something else to do about
What
Madison.
would he say about our legal landscape today?
I think he would say...
From your understanding, as you just articulated.
I think he would say kind of where we started, which is, of course, law. The rule of law is central to all of us, and we need some laws to protect us. But he also warned that what happens when you have too many laws, and he wrote about this, who benefits? He wrote that the moneyed and the connected benefit. they can find their way through mazes of law and regulation, and it hurts ordinary people. And it also, he said, disaffects them from their institutions and from their respect and reverence for law itself. And so my question in this book really is just Madison's old question.
More of our conversation with Associate Supreme Court Justice Neil Gorsuch when we get back for segment 4 of The Takeout.
When the government turns its attention to you, do you want a judge who is responsive to politics of the day?
Welcome back to The Takeout. In this segment of the interview, I talked to Justice Gorsuch, Neil Gorsuch, Associate Supreme Court Justice, about a couple of topics. One, he has kind of carved out within the law in this country, both as a federal circuit judge and a Supreme Court justice, a kind of interesting profile when it comes to issues raised by Native Americans and their history in this country. Also, we talk about the recent proposals to change either the length of term of service on the Supreme Court proposed by President Biden or recently approved ethics reforms within the court.
You have a quote early in the book, and I want to ask you if you believe what the quote says. Do you really believe in hell there will only be law and nothing but law?
Well, I'm not sure I would go quite that far, but many people have. Some of us would enjoy law more than others. I mean,
In the epilogue, you quote Alexander Solzhenitsyn. One of the first books I remember reading and never forgetting in high school was A Day in the Life of Evan Denisovich, and then the Gulag Archipelago. And there's a warning there that you quote a Russian proverb. When it happens to you, you'll know it's true, in reference to an authoritarian state. Mm-hmm. Is an authoritarian state rising in America?
I'm not going to get into contemporary political discussions, but I do think it's interesting.
But you wouldn't have included that if you didn't think there was something to be concerned about, would you?
Yes, I'm about to get to that, if that's all right.
Sure.
Yeah, I do think we ought to look at those words and maybe Tocqueville's words too when he visited this country, right? He said, what was beautiful about America was that we were so involved, we were so engaged with one another, we trusted one another, we worked with one another. But what happens when we lose that? He asked that question. And he said, what happens then when we become so disaffected from one another, from our communities, from our local governments, that sometimes he feared that if Americans lost those connections, our only connection left would be with the state, with the government, and that we would turn there for all answers. And he said the danger would, in his words, something like this: we might become a timid flock of sheep looking for a shepherd.
You are known on this court and throughout your legal career as having a keen eye for the legal interests of Native people in our country, Native peoples, Indigenous people. What is their story in the relationship to the things you're writing about in this book, and why is that an area of law in which you have distinguished yourself, even from colleagues who are regarded as like-minded textualists or originalists?
Well, I think the starting place has to be with the fact that this country made a lot of promises to Native Americans. Treaties, often negotiated under duress, but treaties nonetheless. Promises made. Mm-hmm. And I think the question is, for every judge, do you honor those promises in the cases that come before you? And I think a textualist, an originalist, as you talk about, can look at the words on the page and say, that's what was promised then, that's what they're entitled to today. You know, there's a saying that men must turn square corners with the government. Shouldn't the government also turn square corners with the people?
And that's been your intent in cases brought before you?
All cases.
All cases. Is there anything that this court needs to do in terms of the conversation about its ethics that it hasn't yet done?
Well, Major, as you know, we adopted an ethics code just this term. And I think that was a significant step. Each of us also, who former federal judges, lower court judges, lived under an ethics code and promised to continue to abide by it as best we can. And I certainly take that very seriously, as I know all my colleagues do. The question you raise, I think, implicates certain developments that have happened in the political sphere lately. And as a judge, I'm pretty reluctant to get involved in talking about things that are currently being debated by the political branches.
Is the concept for this court going forward of term limits valuable or harmful?
I give you the same answer, Major. You know, that is right now being debated in the halls of Congress and the White House. And I just don't think it would be very useful for me to comment on it.
Fair enough. In the ethics agreement put forward by the court, do you believe that is sufficient? Do you believe that answers calls either for transparency or more visibility into the interactions, privately or non-privately, that justices engage in?
I think it's remarkable that we were able to agree unanimously on that, all of its provisions. And I think it's
Why is that important, the unanimous part?
Well, you asked earlier about how we get along, how we operate. Mm-hmm. And we try to operate by consensus as much as we can. And I think that's a remarkable thing that we were able to achieve unanimously.
And in a general sense, does this court today or in the future have to understand and care about its public perception? Or should it hold itself in a position in which public perception may run in one direction or another, but the court ought not to care?
Major, you raise a really interesting question about the place that unelected judges have in a democracy. That's really the root of the question, I think. And there's always historically been a tension there, right? I mean, Thomas Jefferson didn't much like John Marshall, even though they were, I think, related. They even impeached one of the members of his court because they didn't like his rulings. Andrew Jackson ignored this court's ruling in the Cherokee case, forcing the Trail of Tears, right? Franklin Roosevelt, the court packing plan. We all know that story. When you and I were young, there were bumper stickers. Impeach Earl Warren.
Right,
or
abolish the war in court.
Abolish the war in court.
I saw the billboards out in the West.
Okay, exactly. Or William Douglas, another Westerner, right? So this conversation's always been part of our national culture. At the same time, an independent judiciary has always been valued by this country, and I think is an important heritage of this country, right? What happens when the lights are on you, when you're in the dock, when the government turns its attention to you? Do you want a judge who is responsive to politics of the day? Or do you want a judge who's going to apply the law and the Constitution to the facts of your case without consideration to those things? And an independent judiciary, our founders fought a revolution for it because they had lived and they knew what it was like to have a judiciary that was responsive to the crown, to a whimsical king. And they didn't want that for the future. They didn't want that for this country. And the truth is, when you're the man in the dock, you don't want it either.
More of my conversation with Associate Supreme Court Justice Neil Gorsuch, that's coming up on your Takeout Outtake Especial.
Getting rid of Chevron is simply a way of saying everybody gets to make their arguments on equal footing.
Welcome to your Takeout Outtake Especial. My conversation with Associate Supreme Court Justice Neil Gorsuch continues. Here we talk about presidential immunity. The Supreme Court waded in on that. And is there any danger in thinking too highly and overlooking some of the flaws handed down to this country by our founding fathers?
You just referenced a king how does that orientation, historical and otherwise, flow through this term's decision on presidential immunity?
Well,
some Americans fear it comes close to creating a kingly-like protection for the presidency.
Well, we can talk about that, but let's start with where we agree. I think everyone agrees that a president in his private capacity, non-official acts, when he's a citizen, acting like a citizen, even when he's in office, is subject to the criminal law just like you and me. No man is above the law. We also agree that when a president's in office, he can be impeached for his misconduct and removed from office.
A political construct, not an entirely legal one.
A little bit of both. The Chief Justice presides. There's a trial. It's not done by us, but there's a trial. But he can be removed from office. We also agree his illegal actions can be enjoined. You can go to court. You asked about the emergency docket. Mm-hmm. You can go to a court and seek an injunction to stop illegal behavior by his subordinates. We all agree on that. Longstanding precedent of this court, Nixon versus Fitzgerald, deals with what happens to a president after he leaves office and is sued privately after he leaves office. And the court held that you can't have a president fearful of civil lawsuits that might chill his behavior while he's in office too much, so that he's presumptively immune from civil lawsuits after he leaves office. There are exceptions. That can be overcome. Everybody knows that. That's been the precedent of this court. The question before us this last term was what happens, and this is the first time it's happened in our history, what happens when one presidential administration brings criminal charges against a former president? And the court basically held that the Nixon versus Fitzgerald framework is the right way to think about that. For his official acts, that there's a presumptive immunity, but that presumption can be overcome. If he's bribed, he can be pursued, even though that was an official act. That was an example we gave. And of course, there was an indictment before us with specific charges, some official, some unofficial, and we remanded it to the lower court to sort that out. So that would be my answer to your question.
Going back to the origins of our country, is there any danger in revering the founders too much for the blind spots they had?
Oh, they had absolutely huge blind spots. We had to fight a civil war for the biggest blind spot.
There were others too.
There are others too. The 19th Amendment. That's a huge blind spot. Wyoming wouldn't even enter the Union.
Right.
Right?
Without suffrage.
Right. That was a big blind spot. Good for Wyoming. Of course, we should be aware of the blind spots in our country. And that's what the whole point of a sovereign people is about. We, the people, can make our way forward and move this country forward in ways that improve it. And I know a lot of people think, what can they do? How can they do it? I love to tell the story of Gregory Watson when it comes to that. Gregory Watson was a student at the University of Texas, and he wrote a term paper about the Constitution. And in his term paper, he noted that James Madison, we're back to Madison, had proposed a bunch of amendments for the Bill of Rights. We know them as 10, but there were others. And one of the others had to do with congressional pay raises. And it said basically that Congress can vote itself a pay raise, but it can't take effect till the next Congress so that there's an intervening election so that the people can decide what they think about it. It had been ratified by a number of states, but not fully ratified. And Watson wrote, well, I think this thing could get through. It's pretty close. There was no time limit on that amendment. Well, he got a C for his paper. His teacher thought it was outlandish. Well, what did Gregory Watson do? That kind of lit a fire under him. And he started a letter writing campaign to state legislatures across the country. And more of them ratified it. And it's the 27th Amendment to the Constitution.
I covered it.
And it was ratified completely in 1992.
I covered that.
So think about that next time you wonder if there's something you can do to help the country.
Last question. There's a long arc of cases that led to the overturning of Chevron. Wasn't the only case. There were cases before that. To those Americans who fear that that now leaves a space for large, moneyed corporate interests to get their way and browbeat the administrative state and avoid the kind of regulations that Congress either asked for or by implication asked for, and are fearful about that.
I'd say just the opposite, Major. How I came to my views on Chevron was as a judge, seeing how it played out in ordinary people's lives. And I'll give you an example. Mr. Denise Robles was an immigrant to this country, married to an American wife with 4 American children. He faced 2 laws, one of which said he could apply immediately for admission to the Attorney General, and another law that said he'd have to leave the country for 10 years and then could apply. My old courts faced that question of which statute controlled, looked at it dispassionately without favor or fear to either side, and said the first one controlled. He relied on that, so he applied for admission directly and immediately to the country as any normal person would do. An administrative agency 8 years later, after receiving his application, said no, said the second statute controlled, said that we had to overturn the judicial precedent because of Chevron and send Mr. Denise Robles out of the country so he'd have to start all over again. 18-year waiting period. Okay? That's how Chevron impacts people. Because what it says is, when there's a doubt about how the statute should be applied, the agency always wins. And last time I checked, Lady Justice out front is wearing a blindfold. And the scales of justice are even. And that every person who comes to court is entitled to have a judge fairly and neutrally try to apply the law to his or her case. And no party is entitled to have Lady Justice peak and favor one side or tilt the scales of justice systematically in favor of any party. Getting rid of Chevron is simply a way of saying everybody gets to make their arguments on equal footing.
Hope you enjoyed this Takeout first ever interview with a Supreme Court Justice, in this case, Neil Gorsuch. Thanks for joining us. We'll see you next week.